Welcome back. So the disappearance of Joshlin Smith has drawn widespread attention, with court proceedings now taking place at the White City Multipurpose Centre in Saldanha Bay. Residents have gathered in large numbers, making it a first for the locals and highlighting how deeply this case resonates within the community. Could more multipurpose centres or public venues be transformed into courtrooms in the future? To discuss this, let's now speak to retired Judge Dennis Davis. Judge Davis, a very good morning to you. Thank you so much for making time for us. I have to say, when I saw this, I thought, wow, this is quite an incredible move, considering that you have an issue with the access to justice, but also sometimes how far courtrooms are for victims and community members to be following some of these cases, because we want to see justice being done. What do you make of this decision that has been taken by the Western Cape High Court Division to turn the White City Multipurpose Centre into a courtroom?
Well, of course, I don't know the real reason for it. I mean, I don't know whether, in fact, there wasn't a magistrate's court which was large enough, which is traditionally what happens in circumstances where a case is being heard by the High Court in an area where there is no High Court building. Traditionally, one uses the magistrate's courts. It probably was felt, I suppose, with some obvious justification, that given the public interest in this particular case by the community, it would be more appropriate to find another venue, or perhaps there wasn't a courtroom within the area which would have been able to accommodate at least a reasonable gallery. But in principle, there should be no objection to such a thing. And in fact, I think what you really are saying in your introduction is that people are entitled to hear justice being done and see it being done. And to that extent, it's a good move. And obviously, this is a case which has interested the community of Saldanha Bay, etc., for obvious reasons. And the fact that they can go along and listen to the way the case proceeds is obviously shows that it's not just that justice is done, but it's seen to be done. So one has to support that.
Yeah. And what does it then do to this whole conversation and what I said in my introduction as well, around how difficult it is sometimes for community members to access these courts, considering how far sometimes the courts are from communities where the crimes have been committed?
No, I think that's probably correct. That if you've got cases of this kind, I mean, I suppose we have to divide things up, don't we? Between, if you could call it, civil cases, which generally would take place in the various high courts in the country. And of course, there are more high courts in South Africa now than there were at the time of the dawn of democracy. But you're quite right. You're talking about a case such as this one, which ultimately has gone to the High Court in an area where there is no High Court, where there is an area where there's therefore no basis by which you could actually have a large courtroom where people would be accommodated, such as would be the case in the large court in the Cape High Court. And you want then to have a place where people can come to. And your argument is that now a lesson that we should learn for other cases? I suspect in selected cases that may be. There are, of course, logistical problems. Remember that all of these various accused, as it were, in a criminal case would be presumably represented by counsel and attorneys. The judge would then have to go to this particular place where there are no real facilities, no research facilities, probably no law reports or anything of that particular kind, all of which make, as it were, the execution of justice slightly more complicated. But we've had, a classic example which did take place in the High Court, and which was a case of monumental importance at the dawn of apartheid, in fact, during the dawn of apartheid, I mean the dawn of democracy, before democracy dawned, was the Uppington murder case, which raged for a very long time in Uppington, where effectively a court was used and the community were able to come to it. There was no hall, I think it was in the courtroom, but it still resulted in massive community. Now, I suppose your point would be, if you can get 300-400 people of the community into a hall and they can watch this rather than, say, 30-40 in a slightly more restricted courtroom, why not? Answer, I agree with you. Yeah. But you have to just take account of the various logistical problems for actually running the trial in a distant place.
Okay. Judge Davis, I'm just going to quickly ask you to just tilt your camera up a bit, It seems to be cutting off. Yeah, perfect. Thank you so much for that.
Okay, pleasure. Sorry about that. Yeah.
No problem.
Technologically illiterate, but carry on.
Technologically illiterate, but definitely a broadcaster of note.
Touche, carry on.
With regards to cases like this, the public interest, we've seen like major cases, like even if we speak, for instance, about the Oscar Pistorius trial, where the decision was taken by the North Gauteng High Court to have 2 courtrooms set up because of the number of people that were actually interested in the case. So you had the main courtroom where Judge Masipa was presiding. Then you had the overflow, some would call it, where other members of the media as well as the public were able to follow those proceedings. Now, with matters like those where you have this huge interest, could this be the route that we should be following as a country? Whether it is, for instance, let's say, for instance, the case is happening in Pretoria and you have a high court that has capacity, but not capacity big enough to carry the number of people that want to come and follow the proceedings.
Well, you may never have the capacity for that, even in a hall. I mean, let's assume you've got a hall. I don't know how big the hall is. I haven't followed the actual proceedings in the Smith case, but let's assume we can get 200, 300, 400 people in it. That's good in the sense that, you know, people show interest and they come and they listen, and that's very good. It's a kind of almost civic education, if you wish. But if you've got a case like the Oscar Pistorius case, you probably would have really, if everybody who's interested in going, you probably would have needed the Loftus Versfeld Stadium. What I mean by that is, you know, the interest was so widespread that no kind of one building will be good enough for that, which is why television, and perhaps in circumstances where people don't have access to television, radio broadcasts of the proceedings are the only other way to go. So you'll always have the limitation. But if the principal point that you're trying to drive at is, should we be searching for venues which allow people within the community to come to see cases which have clearly and massively affected them, well, then that's a very good thing, and that should be supported.
Yeah, just quickly in conclusion, with regards to the logistics. So when Judge Erasmus was doing his inspection, he says that everyone's safety and comfort has been seen to, and I'm satisfied that the proceedings will take place at the Multipurpose Centre. All normal court protocols will still be held. Just quickly speak to us about those issues in terms of the safety for everyone, because ordinarily when you go to a court, you have all of the security features that are there, security features that you normally wouldn't find at any normal public facility.
I agree with you, but I'm not entirely sure, having spent more than 20 years of my life in high court buildings, where the security is quite as formidable as you suggested is. Regrettably, it isn't. But the fact of the matter is that you should have police there, and essentially be able to have checks at the entrances so that, you know, people don't bring in arms or knives or anything which would threaten the public. Surely, you know, ordinary sort of security is not that difficult to deal with. I'm sure that's what he's talking about. And as for the rest, the actual fact that you can rearrange a hall so that it comports with all the requirements of the courtroom, the recordings, and sufficient space for counsel and for the judge, I don't think any of those are insurmountable difficulties at all.